Ogezaako okugamba nti natta abantu n'agenda n'aleeta abantu be natta kati abantu abaafa bawulira
wakwata ku baganda k'otuule wetukiwuma nnyuma
oyimanyira wa Natasha
temujja mmanira buganda muba motherfuck muddewa
kibadde kitya mu kkooti?
Omulamuzi avuddeyo n'ayogera nga bw'ayogedde kiri nti beyiro yo bagimumye bagambye tukomawo nga meka 26
ogw'okumeka
March
26th of March. Era tuli mu kulwana okulaba nga next time tugezaako okuleeta bashurities abali waffe sooka oviire emmotoka eyitewo. Tulina obuzibu bwetwasanze nti bashurity atamanyi meaning ya shurity ye muntu eyeeyimirira omuntu omuwawaabirwa. Shurity twaleese bashurity babiri tubaddeko omwami Ebya Extra Media zavugiddewa then ne sister w'omuwawaabirwa naye batuuse ebibaluwa byabwe byonna jjukira bye bino ebituwammanga ebyetaagisibwa okweyimirira omuntu. Weetaaga ebbaluwa ya chairman, weetaaga photocopy ya national ID ne national ID yennyini byonna babadde babireese ate nga biri valid. Naye State Anthony abagambye nti tebalina credibility ereetera kweyimirira muntu, kitegeeza their credentials are invalid. Bwe batyo ne babeera nga ebibaluwa bwabwe ate ne Ebya Extra Media tufunye obuzibu nti akwaatiddwa eyabadde okweyimirira akwatibwa n'atwalibwa ku CPS. Alina obuzibu n'omwami oyo yayambala olubugo era twagala okwebaza nti abantu bambi bali kujja kubeererawo pressure. Nze siwagira kyakumusiba ate n'ekyokufuma kabaka sikiwagira kubanza omwana oyo mulaba nga alina obuzibu ku mutwe. Nze mbadde nsaba before they do anything omwana basooke bamutwaleko ebitabita bamukebere omutwe okubaako ekikyamu then awo bamuteeke ku treatment then bwe bamukebera ng'omutwe mulamu if the head has no problem nga tali mentally ill awo balyoke bamukole ki bamugire. Naye nga tukoma nga 26th of March tulabe nga twogera ebirala ne as for now kyekyo kivudde mu kooti. State abadde mukambwe nnyo.
Ki kyoyinza okuba nga owaba tiktokers banno abakyali ebweru? Kati
wano we tutuuse omusango gukalubye, omusango mugumu. Twali bakamukwata first session twagamba akasango katono osegera nga bakamukwata first session twagamba akasango katono era abamu twawaganze nawaga nengamba omusango oguli beyire busegeza omusango mutono. Naye tulabye abasajja ab'ebitiibwa okuva Emmengo nga bazze wano muganda wange, abasajja bambadde amakanzu, nze ndabye emmotoka y'abambo waawo ebweru osegera kitegeeza kati Mmengo eyingidde omusango direct. Emmotoka y'abambo we baddewo nga bambadde amakanzu babayita bagalagala, abagalagala bali awo bweru bakambwe bazibu. So pressure omulabye bw'abadde ajja ku first session ajja aseka asimayiringa alabira ddala nze ndabira ddala omuntu ali mentally ill. Ono omwana aliko ekikyamu ku mutwe osooke bamutwali bamukebera omutwe gwa pressure tegukola. Nze ekyo nkirinako proof kuba nze nina sister we Akisale yankubirako emabega kaawo nangamba fe oyo omwana twamuvaako olw'ensonga nti avuma maama we avuma abalalala awo bikiso bonna bonna yabayisaamudde eggaali. So omuntu bw'atuukira okuvuma abo abantu kitegeeza asobola okuvuma buli muntu akola ki amusala. Tubadde tusaba bwe kiba nga kisoboka kooti etumye ekibaluwa nti omwana oyo basooke bamutwale bamukebera omutwe guliko ekikyamu. Nze mulaba omusango gwaliko munene naye wajja mu kooti bw'ati aba aseka osegera amwenya bw'ati n'aseka osegera kati okumwenya ne state aba anyiiga era bamugambye nti your bail has not been granted n'amwenya n'abagamba n'atambula n'agenda. So ekyo kikulaga nti aliko obuzibu. Kati waneno share price n'abalala bagenda ne bamulabako mu kkomera eruzira bagenda ne bamukyalirako naye ng'ali mu kukuba sama eri mu action be gye bamusibira ye agamba lubiri lwe era agamba agenda kuvayo n'abambowa n'abagalagala. So olabira ddala omuntu aliko ekikyamu ku mutwe. Tetusaba kooti ekyo banakitukolera at least balema musiba we batyo osegera kubanza ebyaddala siwagira kumusiba naye nekiyakola nakyo sikiwagira. Kino eno information message eno egenda eri ba tiktoka bonna bannange tukozeseza bubi omutimbagano bagenda kutusiba batumalewo. Nze nkubuulya bwe tuteetereze bagenda kutusiba batumalewo. Juko ogenda kuvuma omuntu bwoti pa mpola asirike jukira pressure asoko yatandika okubanja entebe ng'agibanja bulungi nga takozesa bigambo biri vulgar nate bwe yatandika okukozesa ebigambo biri ebibi n'agibanja mu manje embi. So abantu ne batandika okukola ki ne banyiiga ate n'ekirala pressure okuba mu custody ya police nakyo kimuyambako osegera pressure okuba mu custody ya police kimuyambako olw'ensonga abaganda bali solid muganda wange pressure we bamuta we baba bagenda kumutta. Nze nkubulira bayinza obutamutta ne bayinza omukola ekintu. Nze nina abaganda bemmanyi eyofe nga bo bakola n'obukuukulu ne bagamba oyo omwana ne bamuta bamutuwe. Osegera bamute bamutuwe. Kuba kati tulina abaganda abedda abaliwo nga bo bagamba nti bw'okwata kabaka anattisa kabaka ekitala ndi muttisa embazzi. So kati be baganda abaliwo kati abayingidde musango first session saalabako muganda waggulu awo naye kooti ey'okubiri obalabi basajja bazeeya abasajja abaddala abasajja ab'ennono abasajja ab'ensonga. So ffe tusabe busabi ekirungi nti pressure bambi abantu tebamusuuliridde mikwano gye tusigadde tujja ne bwe banaamusalira era kyempulidde nti bagenda musalira emyaka inkesi gumuse muvi omulamuzi agambe bagenda musalira emyaka 5. So 5 years in prison bweweekwata obulungi emyaka 5 osobola okwekanga nga bakusaliddeko omwaka kuba kati remission ennaku zino tebakyatemanga luli baali batemanga emyaka 5 bakusibayo 2 kitundu tekikyali ekyo weeyisiza otya mu kkomera tovumye bantu bw'otuuka mu kkomera entebe togenda sigala ng'ogisaba osegera so kati ebyo byonna tuba tubitunuulira naffe katusabe busabi emyaka 5 era ne banaagimuwa era bajjajja gisaavinga giggwe baana basaavinze emyaka 10 emyaka 2 naye kino kibe kyakuyiga boyi bw'oba ovuma abantu mulimu abantu abatavumika bodda kakono wuno muvume kuba tagenda kusiba nze chikeni waabwe nze chikeni waabwe ojja kunvuma ebigambo by'oyagala no problem nze chikeni waabwe naye mulimu abasajja batavumwa nze mbeera unengamba kale entebe singa yasaba ya President Museveni
bangi mwali muwagizi
singa kyangamba singa entebe yasaba ya President Museveni kuba talina buzibu omuvuma nga bw'oyagala osegera bamuvumye enkya neggulu naye yakabaka boyi eyo yonzibu
abaganda bali solid
abaganda bakamba muganda wange alejjukira bamu bamupikanga awakingi bali bakamukwata mwana n'agamba tutusonyiwe taata eye pressure sebo gusinze taata kati enaku zino bali free pressure nange kenyini kwendi ku free pressure naye nze nakola vidiyo ezibuulirira omwana oyo nemugamba pressure kabaka kali yandivumye Katikkiro wabanga yali yagala nnyo okulumba Obuganda naye okulumba butereeve empologoma tyaha nti njagala ntebe yange eyo entebe yange mugimpe muganda wange so ndowooza kyekyo baganda
kigeni twaleo tulina ekibuuzo kye tusaba okubuuzaako tuwulidde nti Abadde azze okumweyimirira omukulu amanyiddwa nga UG Extra Media bitambudde bitya
UG Extra Media abadde surety ye muntu eyeyimirira omuntu ebintu
tetugenda kukiyiya Ssaabasajja Kabaka wa Buganda wali bawezeewo bantu bana waliwo gwe manyiko bamwita Asha Blessing yasazeeko dda nnyinza omukulengezaako
abagala
Stand charge 8 counts. 4 of these 8 counts are for hate speech. Over section 26 section A1, A, C, and 2 of the Computer Misuse Act of 2011 as amended, where it is alleged that the said accused has sold between August 2023 and February 2024 in the areas of Kampala district or thereabout, or using a computer via TikTok account at Pressure 24/7, shared information which is likely to ridicule or degrade or demean and promote hostility against the persons to wit His Excellency Dr. Museveni, President of Uganda, in count number 1, His Majesty Ronald Mwenda Mutebi II, the Kabaka of Uganda, in count number 2, Right Honorable Anita Among, the Speaker of Parliament of the Republic of Uganda, in count number 5, And Honorable Joyce Nabosa Semugwawo, this is the count number 7. Inside with 4 counts of malicious information under Section 26C, Subsection 1 and Subsection 2 of the Computer Misuse Act of 2011 as amended. It's alleged that the said accused between the month of August 2023 and February 2024 in the areas of Kampala district or thereabout, while using a computer via TikTok account at Pressure 24/7, shared malicious information relating to the following persons. 1. His Excellency Dr. Museveni, the President of Uganda in count number 2. His Majesty Honorable Mwenda Mutebi II, the Kabaka of Uganda in count number 4. Right Honorable Anita Anet Among, the Speaker of the Republic of Uganda in count number 6. And Honorable Joyce Nabosa Semugwawo in count number 8. The accused person denied all the 8 counts and applied for bail through 4 advocates, namely Masaba Raphael Gideon, Tumusime Kakulu, Tumusime Kato, and Ochida Ho. The accused presented 2 sureties, namely Numbers of Brenda, age 35, who operates a cosmetic shop and sister of the accused. Ibrahim Sembacha Matia, age 32, who operates a phone and accessory shop and friend of the accused person. The state represented by Land Chief State Attorney Richard Bidi Gumbuka opposed the application on the following grounds. And the best of the affidavit in reply deposed by Detective I.P. Pamizo Agre, and the grounds are the following. That the applicant or accused person has no fixed place overboard, that the area local council one chairperson Chakizon in Najana Mputi is sold him in date and next C to the affidavit in reply stating that he has never been a resident of his area. That he was arrested from Excelsis Garden Hotel in Ntinda, where I lived for 2 months, and that the charge sheet has his residence as Kauga in Mukono, and therefore the accused person's residence is not clear, yet it's a key factor to consider in granting bail. The accused has no credibility given the fact that he has no place overboard, that his chances of absconding are high and therefore is a flight risk, given that he lacks a fixed place overboard. Inside the case of Francis Onebe versus Uganda, stating that it would be risky for his court to release an accused person who has no fixed place overboard. It was further established on the Land Chief State Attorney that the 2 sureties are not substantial, that Numbers of Brenda insists that the accused person is a tenant at Church Zone without credible source of income, or Mr. Sembacha Ibrahim Matia was disowned by the area chairperson of Muzana Zone in Kisenyi, where he allegedly stays. He concluded that the two accused persons, that the 2 sureties have no fixed places overboard, and that Numbers of being a tenant can shift anytime, and on credible sources of income, he cited the case of Mugera John versus Uganda. He further stated that the case is of public interest, and he cited the case, the ruling of Justice Tigulia in the consolidated administrator's application 45, 46, and 47 of 2015. It was further the state's submission that the accused will be unsafe outside prison and that the offense is grave in nature. He prayed that bail will be denied, and that if this court is inclined to grant bail, it should impose extremely stringent bail conditions. In rejoinder, Mr. Masaba submitted that the offense is not grave in nature as alleged by the state, as it attracts a maximum sentence of 5 years in prison upon conviction. That the AIS chairpersons who disowned the applicant and the sureties were intimidated by the investigating officer. That the state already has enough evidence against the accused person, and that's why we will charge him in court, and that therefore the accused person shall not interfere with the investigations. It was a submission that the sureties are substantial, and that Numbers of being a tenant cannot bar her from being a competent surety as long as she can ensure that the accused person attends trial. He confirmed that the accused has a fixed place overboard at Church Zone and Nikapoli Budaka, where he stays during holidays with his mother. He prayed that the court listed the accused person on very lenient terms, particularly on non-cash bail. The issue now before this court is whether or not the accused person has satisfied the ground for release on bail. It's strike law that every accused person has the constitutional right to apply for bail, which court has discretion to grant or not to grant in accordance with the law. I've carefully addressed my mind to paragraph 13 of the Constitution, bail guidance for cost of judicature, practice direction Plus Session of 2022, particularly paragraph 13 on concession for grant of bail. The same paragraph states that the court shall consider the following in handling a bail application. 1. The gravity of the offense. B. The nature of the offense. C. The antecedents of the applicant insofar as they are known. D. The possibility of a substantial delay of the trial. E. The applicant's age, physical and mental conditions. F. The likelihood of the applicant to attend court. G. The stage of proceedings. H. The likelihood of the applicant to commit another offense while on bail. J. The safety of the applicant, the community, and the complainants. K. Whether the applicant has a fixed place of abode within Uganda or whether he or she is ordinary resident outside Uganda. L. Whether the applicant has sufficient sureties within Uganda to undertake that the applicant shall comply with the conditions of his or her bail, among others. I note that the residence of the applicant is not clear. The charge sheet has his residence as Kauka Mukono, and when the charges were read to him, he never denied this particular fact. Later introducing him came from church zone in Najana Kumbi to see a person who still one assist this on the said accused person, as Kay said that not a resident of the area. There is also another letter from Kakoli Nibudaka where they allege that he stayed with Maza during holidays. Upon the police, he was arrested from a hotel in Itinda where he had stayed for 2 months. In light of paragraph 13(1)(k) of the bail guidelines, I don't find that this person to have fixed place of abode. The evidence on record shows that he stays in Church Zone, Kauka in Mukono, Kakoli in Budaka, and the hotel in Itinda. Paragraph 15(1) of the bail guidelines sets out what court has considered in finding surety substantial, and these include the age of the surety, work and residence service of the sureties. Surety numbers of render as a place of work and residence at Church Zone, and matters to the tenant is also assist at the accused person. In light of paragraph 15(1) A and E of the bail guides, I find her substantial. However, suit number 2, Mr. Sembatia Ibrahim Matia, has no clear place of residence, as it was disowned by the area chairperson of the zone where he alleges to be staying. He has no clear relationship with the accused person. A mere says that is his friend. And in light of paragraph 15(1) B and E of the bail guidance, I don't find Mr. Sembatia Ibrahim Matia a substantial surety stand for the accused person. An applicant who has no fixed place of abode and without substantial sureties cannot be released on bail. If court did so, it would assume a risk as stated in the case of Francis Onebe versus Uganda, which was cited above. I'm not ready to assume this risk for the reasons stated above, and for those reasons, I do reject the bail application and further demand that choose the 26th of March 2024 when the case shall come up for mention.
Your worship, this is not a very grave offense, like murder. And even in murder cases, your worship, court grants bail. So I invite court to disregard the submissions that the accused has multiple offenses against him as a ground for not granting him bail. Your worship, counsel submitted that the accused does not fix place of abode.
And you're saying that he has fixed place of abode where?
Your worship, we earlier informed the court.
The just says the accused has a fixed place of abode at?
We still maintain that he has a fixed place of abode at Church Zone. And his mother's home during the school holidays in Budaka.
Address me on the business of Toga.
Your Worship, I wanted to first address. I was driven by that because
I'm writing you because I did emotional something.
Your Worship.
Has closed his eyes to these glaring gaps in this application. Let's have that. Just in case this court closes its eyes on the glaring gaps in this application, right from the applicant, the sureties, then we pray for extremely stringent terms.
What am I to extreme
This is prosecution. I mean, this is prosecution.
So you pray that he pays 30 million cash.
And we are saying in case this court, which of course our prayer is that court should dismiss the application. But in case this court exercises this discretion, then the terms should be extremely harsh. Not harsh. But deterrent. Yeah. And Your Worship, these terms we are talking about, which we even don't want to mention, but for example, depositing the land title in the name. Because Your Worship, I don't speculate, but the issue of address is a matter of fact. But besides, prosecution pledged to verify the documents. If, for example, Violent Brothers knew of that, maybe probably they took instructions prematurely without interviewing the applicant. I'm not accusing them, but they should have brought this information that time when they were making this application. This is an afterthought. This is an afterthought because they are operating no obstruct. As prosecution is proceeding to verify the residence of the accused person or applicant, they are busy operating in abstract because we should have verified that. And now that we can't verify that, we pray that Your Worship Court finds him further doesn't have the interest of our God. Your Worship, in a nutshell, is that this person, as per Annex W, Your Worship, Annex W, the fifth person is starting with 8 counts. 4 for hate speech and 4 for malicious information. These are serious kind of charges or counts which are multiple in nature. They are multiple in nature. Found in the custody.
Your Worship, I would like to object to that.
You will get the help of me.
These are investigations.
You can not talk to
Your Worship, is there permission therefore that the applicant is safe in custody? But besides, it is the applicant is an administrator of Pressure Twitter account called the Pressure 24/7. He's the administrator of that account. So my mistake, Pressure 24/7. At Pressure, guys, 24/7. I'll find paragraph 11 of the affidavit. I'll refer to paragraph 11 of the affidavit. TikTok. Yes, TikTok. Yeah. Yes. What is the implication is that once he gets out of custody, the possibility of him deleting and interfering with investigations are so high. And yet this TikTok account is a source of investigation. George, I'm not an expert. But once you're an administrator, then you're capable of doing anything on that account which you administer. Besides, that says you're saying we can do investigation? Yes, exactly. Conclusion? Your Worship, I just want to furnish you with a copy of the ruling of this application 0.5, 0.6, and 0.7 of 2015. As prosecution, this matter is of public interest. And the only way the public interest can be protected is by keeping the applicant in custody until the matter is complete. The applicant in custody until the matter is complete. The applicant attacked very important persons in this country, that even his life is insecure. And actually being in custody is for his own benefit. Being in custody is for his own benefit. In fact, if I were he, I wouldn't even mention the word application for bail. First of all, I have a copy of this ruling for court. You are saying that he's safer in prison? He's safer in prison, Your Worship. And Your Worship, it's not only speculative, but I'll refer you to paragraph will the street be in position to control it practically? None of the shooties has a passport. They don't even have a passport. The best they can do is to use porous borders in case they accuse person absence. And we have an experience of kkomera who was charged with the cyber crime, who ran away. These are things we are talking about and they are a reality. You are talking about the surety, not the abuse person. Your Worship, I would like to refer you to the case of Mogera John versus Uganda. Mogera John versus Uganda. This is miscellaneous application number 0021 of 2023. 0021 of 2023. International Crimes Division of the High Court. This was by Lady Justice Alice Comhans. Your Worship, while the judge was denying bail to the applicant, she referred or she relied on the ruling of business application number 002 of 2022 by Honorable Justice Elizabeth Jane Advisa. Who, on page 11 of that ruling, emphasized the importance of credible sources of income for a surety. And in that case, because the accused person does not have a fixed place of abode, it became extremely difficult for police to locate him and arrest him. I refer you to
arrest him and
to locate him and arrest him. Locate and arrest him. I refer to paragraph 12 of the affidavit. In respect to the accused person himself, Your Worship, refer to paragraph 6. The letter which introduced him was received, and we annexed it as an extra. Yeah. Annexed. On verification, it was found out that the applicant, who is the accused person, has never been a resident of that place. The chairperson LC1 confirmed that through his letter, which is the resident of the place which is in there. Yes.
paragraph 1.
This is paragraph 7 of the affidavit. His annexure is matter.
So the exam chairman confirmed the next step.
Yes. And Your Worship, that explains there's some connection between the chairperson's letter and the place where the accused person or the applicant was absent from. The applicant was arrested from a hotel called Alexis, which is found in Tinda. He has been there for 2 consecutive months. An implication of that is that he does not have a fixed place of abode, which is very critical to consider why granting for him on bail. Yes, that is the applicant's right. Apply for bail. But it's the discretion of the Honorable Court to grant it. applying for bail, the applicant wanted two sureties. That is the numbers of Brenda and Ibrahim Sembatia Matia. Your Worship, prosecution sought to verify one, the validity of the recommendation letter to the accused person or the applicant. And the recommendation letters, the recommendation letter for the applicant, numbers of Brenda, and people I think somebody. We instructed the police officer, Detective AIP Bank Republic, who is the investigating officer, one of the investigating officers in this matter, to ensure a thorough verification of the same. He did so, and thereafter swore an affidavit which we filed in my office and served home to accuse. Yes, this morning. Okay. Your Worship, I verified to the state affidavit, the verification, because it forms key in this. Your Worship, to confirm that it is the investigating officer in this matter, we filed.
Spend the holidays of the man. I actually prefer that we submit this letter and the mother's photocopy of the mother's national ID.
Mr. Anderson, it is alternative residence for the accused.
Yes, Your Worship.
Your client is educated as a businessman. Does he study? On the time sheet, businessman.
Your Worship is a student.
And also businessman at the same time?
Your Worship, I don't
That's
know.
what I have here. I don't know that I have the same shine sheet. The shine sheet is indicated as a businessman. The other is saying that he's a student and sometimes in holidays he visits the mother.
Yes, Your Worship.
So what does it mean? You don't like advertising for people? And so at the same time?
Your Worship, I only knew that he holds a TikTok account.
I'm not aware.
That's what I was
TikTok
aware.
account. Just read it. I'm not on TikTok.
That's okay.
Your Worship, let's proceed with your response. You will address this.
Yes, very brief, Your Worship. Richard Chief Secretary for my colleagues, Mr. Mekato, Conchidabo, and Masara, and Masaba, Raphael Gideon, all for his family. Your Worship, this matter is coming up today for prosecution's reply to the application for bail.
Your Worship, I wish to address both before we get the reply from my land colleague, the Chief Conductor.
Yes, Madam. Yes, Madam.
I also pray that before we get the reply from the state, I did not appreciate the sensitivity of this matter. That yesterday I received a phone call from one of the sureties informing me that the chairman,
I received
a phone call from one of our sureties, that is Nambozo, Brenda, the sister of the accused. She informed me that her resident chairman had cautioned her why she had not informed him that the person was introducing had actually abused someone very important. Your Worship, basing on that, we took steps and obtained another letter in respect to this confirming in respect to the accused person. As a result, Your Worship, we got a letter from the village where the mother of the accused comes from.
alimukwatako buli mwoca awangale ayisa abasajja kabaka agunde magulu nyondo alimukwatako buli mwoca muwenda mutebi mu nyango alimukwatako buli mwoca muwenda mutebi mu nyango alimukwatako buli mwoca bannange mwenna ababadde ku live yange okuva gyona